Call Robert Brown. Mr Brown.
Thank you very much, Presiding Officer. The issues raised by the bill have been very complex, as has been said, and the divided view amongst solicitors has made assessment of its merits particularly difficult for the Justice Committee. And I'm bound to say that although we paid tribute earlier on through the convener to the evidence given by the various witnesses, the case for the bill was not helped by the highly unimpressive evidence given by Which and the Office for Fair Trading, which, far from establishing the basis for the bill, tended to undermine the case for it substantially. Part of the difficulty is, as has been touched on, is that the bill has got implications which are different for different parts of the legal profession and the so-called legal services market. I have to say that I strongly dislike the concept of a market to describe my former profession. It's a highly inadequate definition of what solicitors do and the context in which they operate. But our whole approach to professional regulation has changed profoundly since the banking meltdown. Much attention in that context focused on the faults of light-touch regulation, but I believe that the real problem in banking was the replacement of traditional, prudent and professional banking practices by a new breed of money wizards with too little depth in the banking profession, too much adherence to slick sales methods, greed and obscene levels of unmerited bonuses. In short, it was a problem of the loss of ethics, not one primarily of the failure of regulation, and I think that has lessons for us here as well. A vibrant legal profession with values and standards developed over many years, independent of government, not beholden to outside funders, seems to me to be at the heart of our democracy and of the rule of law. Now, the desire to allow the development of new business structures is driven primarily, as we have all, I think, agreed, by the larger commercial firms. It is not commonly recognised just the extent to which English law has become the international legal system of choice, not just in these islands but across the rest of Europe and beyond. The committee raised concerns we could gain equal access to the English market for Scottish legal firms, only to find ourselves barred from parts of the continent where there are greater restrictions on who may practice law and under which business model. I think our fears on that front were not established, but in any event the issue of access to the European market is dwarfed by the need for equal access to the much larger English market, and I am therefore satisfied that it is in the interest of Scotland to allow our commercial firms to operate in comparable ways to that of their colleagues in England, and to do so under the umbrella of the Scottish legal system. But I am by no means convinced that these requirements about business structures and ownership and investment necessarily apply to anything like the same degree to the bulk of the profession operating in private practice. And we have to draw, I think, some implications from the hostility to the proposals articulated by the Scottish Law Agents Society and others, and by almost half the membership of the Law Society. Ways must be found, I think, of modifying the proposals, particularly insofar as they affect that part of the profession with no significant international or cross-border practice. Now, I know it is said that alternative business structures are voluntary and that no one is forced into new structures, but the reality is that wider arrangements for funding, for ownership, for partnership with other professions will affect everyone. Unrestrained competition in other spheres has seen the virtual disappearance of traditional town or suburban shopping centres in many areas, of post offices and even of off-licences, and it will not necessarily be any different with solicitors, where there is an issue, I think, of less competition and less choice rather than more. The second implication, of course, is that Scottish solicitors must continue to belong to and be regulated by one body. David McCletchie rightly talked about the key components of the guarantee fund and the master policy, but these are dependent on the continuing contribution of the whole profession, not least of the larger firms, without which the economics of these key client protections could become a bit more shaky. Let me therefore sketch out what I think is possible. First, there is scope for some multidisciplinary partnerships. An obvious example is between solicitors and accountants or other tax professionals. But we have got to be careful in this regard, because it does often raise the conflicts of interest which David McCletchie rightly warned against. And the suggestion of partnerships with surveyors, made by Which, I think it was, seemed to me to be improbable in the extreme and shot through with undesirable conflicts of interest. Secondly, I think we have to look carefully at the idea, which we seem to be going forward with, of multiple and, I suppose, competing regulators, with all the complex issues that brings about. I do think that needs to be reconsidered. I do not mean by that we should be looking at the super-regulator role, which the Scottish Government rightly, I think, put to one side. But no one would suggest a rival regulator to HMIE, for example. The Law Society, I think, is the obvious regulator, and we should perhaps consider whether proceeding on that basis is one option available to us. One very encouraging outcome of the complex proceedings at the Law Society was a clear recognition and commitment to the importance of the society being the key regulator and member support for that involvement. Thirdly, I think we have to be more restrictive than the current bill is as to outside ownership and investment, with all the problems of designated persons and undue and unprofessional influence which we've talked about. We don't want any Robert Maxwells in this sphere, and that was one of the clearest messages from the Law Society's debates on the issue. On behalf of the Liberal Democrats, I am prepared to offer support of the general principles of the Legal Services Scotland Bill at stage 1, but this is only on the basis that a fundamental rethink is required of some of the details which may involve substantial and radical surgery of the bill at stage 2. We make at this stage no commitment to support the bill at stage 3. A satisfactory resolution of these challenges will require statesmanship and flexibility on all sides. I have no doubt that the Justice Committee stands ready to respond properly, and it's certainly not an issue complicated by party positions. But can I make the suggestion that the Minister might consider building on his meetings with the various bodies involved here by a more organised round table comprising representatives of the Law Society, of the Scottish Law Agent Society himself and his officials, and perhaps members of the Justice Committee, to re-examine some of the principles of the bill along these lines in the light of today's debate. Let me finally say one other thing. Very few areas or functions are the sole province, as I discovered somewhat to my surprise actually, of professional lawyers, whether solicitors or advocates. But the public would normally expect to rely on the advice of a qualified professional to help them resolve many practical business and personal issues, just as you'd expect a complicated medical operation to be carried out by a trained and qualified surgeon. And much of the talk, in my view, about opening up the market, about increased competition, is actually hogwash. It's about opening it up to people who are not professionally qualified in law, who don't subscribe perhaps to the ethics of the law, and who in some instances may regard the offering of legal services as the same as selling cornflakes or yoghurt. That is not my view of the law, of the profession of the lawyer, or of what the public expect of lawyers. And it seems to me that the Legal Services Bill must sustain the legal profession. It must, in the convener's words, strengthen it rather than weaken it. And it must do so because it's in the public interest to do so. Let me say, just in one word of conclusion, Presiding Officer, that none of the difficulties here are the fault of the Scottish Government. The Minister has given great enthusiasm and great technical expertise to the proposal. They proceeded after proper consultation and on what they thought was the view of the legal profession. And as has been said also, the Law Society officers have also formulated their views in accordance with the democratic rules of the society and have had a somewhat torrid time as people got to grips with it. This is a difficult and complex area. We do require, I think, flexibility and statesmanlike approaches to deal with it, and I think getting it right is of significant importance to the future of the profession.